Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney client relationship. This communication may constitute attorney advertising.
Welcome to AI Council Code. The AI Council Code is here to keep you up to date on all legal issues arising in the modern business frontier. I'm your host, Maggie Welsh, and today we're doing a quick podcast on the Copyright Office's recent report on AI, which was released in May 2025. This report is significant because it focuses on fair use in AI model training. The report is a pre publication version released in response to congressional inquiries and stakeholder interests. It addresses the use of copyrighted works in developing generative AI systems and whether such uses require consent or compensation from copyright owners. To discuss key takeaways from the report, we have brought back Joe Cahill from Baker Botts' DC office to discuss. Hi, Joe. Thanks for being with us today.
Hey, Maggie. Thanks for having me.
So, the third report from the Copyright Office on AI has generated a lot of buzz. Why don't you start by telling us what it is and what the scope covers?
Of course, first off, this is part 3 of this ongoing study from the Copyright Office. We had the first part, which came out last July, focused on digital replicas. Part 2 came out in January, which examined the copyrightability of works created by AI. This part 3 really dives into what many consider the central challenge, the use of existing copyrighted material to train generative AI models. It's crucial to understand that this report is a result of extensive public consultation. The Copyright Office issued a notice of inquiry and received over 10,000 comments from a wide range of stakeholders, including creators, tech companies, and academics, basically everybody with a stake in this. This document represents the office's effort to synthesize these diverse viewpoints and provide its analysis.
And the report starts off by really delving into some technical aspects of AI development, which I know we've discussed is so important to really understand what the tech is so you can identify the issues. Can you talk about how the report delves into those AI technical issues up front and why that is important for setting the stage of the report?
In the beginning of the report, it covers various foundational concepts like machine learning, the process of building models, and emphasizes the crucial role of vast amounts of training data, how this data is acquired, curated, and used in the actual training process. The report also touches on a concept called memorization, which is relevant to how models might retain and reproduce parts of data they were trained on. And it looks at how these trained models are then deployed in various applications. This technical understanding is foundational because the subsequent legal analysis, especially concerning copyright infringement and fair use, hinges on understanding when and how copyrighted material is used or reproduced throughout this complex pipeline, from data collection to model output.
I agree. And so let's talk about infringement. You mentioned copyright infringement and fair use. The report talks about 4 different parts of the AI model and different infringement considerations with respect to those parts. So, can you talk about what are the considerations with respect to the different parts of an AI model?
Tying in that technical explanation from the report, they get into different aspects of what might constitute infringement in the copyright space, even before they get to defenses like fair use. So, regarding the first part, data collection and curation, this is the act of gathering and preparing different data sets, which often involves making copies of copyrighted works. Developers make multiple copies by downloading, transferring, converting, and creating modified versions or subsets during this data collection and curation process. The next part is training, which is key. This is where the model learns from that collected data. And the report indicates that this involves further reproductions, such as when works are temporarily reproduced or shown to a model in batches during this training process. The report goes to the underlying model weights. These are the parameters that result from the training process itself. If these weights effectively memorize and can lead to reproduction of substantial parts of copyrighted works, there's a strong argument that copying the model weights implicates the reproduction and derivative work rights of the original work. The report analogizes this to how we might have digital files encode content. And then One of the final aspects here is the report specifically calls out retrieval augmented generation, or RAG. This is another area of consideration for infringement. The office notes that RAG involves the reproduction of copyrighted works, and this can happen, for instance, if an AI developer copies material into a retrieval database, and then the AI system accesses this material to potentially augment its response and use this replicated copyrighted work to make its response more precise.
Awesome. And I want to move on and talk about fair use. But before we do that, I think it would be helpful for the listeners if we could explain briefly what the authority is for this report. Are they looking at cases that have been out there? Where are they pulling these ideas of infringement from for this report? And is it binding on companies? Can you talk a little bit about that?
Yeah, so the report does spend a decent amount of analysis talking about existing precedent in case law. And it uses the different standing case law to reason out some of the things it discusses about both infringement and its defenses. The report also acknowledges, and I think it's in the sense of trying to make sure that this report is dynamic and can stand the test of time as AI's technology is moving so quick, that there's various litigation happening throughout the country in all of our courts. And I think it has a mind for that to say, this is where we stand now. This technology is new, and we're probably going to have new case law in the future. It does root a lot of its analysis in existing frameworks from prior decided cases. In terms of if it's binding on companies, it's not going to be per se because it's written on these four corners of the paper, but it is indicating a synthesis of where all of the case law stands now and where they think it's going. And it'll probably be pretty persuasive for future litigations. So not binding today, but I think if you're operating in a space that's outside of the confines of how this report analyzes copyright, you should be more cautious.
Great. So let's talk about the defenses to infringement and talk about fair use and what practitioners can take away from this report about fair use and how it would apply to the infringement analysis.
Yeah. So fair use is given a substantial amount of the pages of this report, and there's a decent amount here. So I encourage any interested listener to go and read the report itself. Fair use in this report is a very complex area. The Copyright Office stresses that fair use is going to be a flexible case-by-case analysis, balancing out all the statutory factors in the case law, which we already discussed. The report doesn't give a blanket yes or no to AI training qualifying as fair use. Practitioners should take away that the specifics are really going to matter. Let's touch briefly on the four factors as the report sees them for fair use analysis. The first factor is the purpose and character of the use. The transformative of this aspect is key in the office's report. Training a large general purpose AI model on a diverse data set will often be seen as transformative because the AI is learning patterns to do many things, not just regurgitate the input. For instance, using a book to train an AI for content moderation is very different from the book's original purpose. However, this is a spectrum. If AI is trained specifically to generate outputs that directly compete with or share the purpose of the works it was trained on, say training an image model on a specific artist's portfolio to make more images in exactly that style, that's unlikely to be seen as transformative. The report calls such uses, at best, modestly transformative, and pushes back on arguments that AI training is inherently transformative simply because it's analogous to human learning. The office calls these views mistaken. On the second factor, the nature of the copyrighted work. This factor looks at whether the works used are closer to the core of intended copyright protection. Using highly creative or expressive works like novels, movies, art, or music, this is less likely to be deemed fair use compared to using more factual or functional works. The office acknowledges that the unpublished status of a work can weigh against fair use. This factor is going to weigh against fair use in those cases. The third factor is the amount and substantiality of the portion taken. And this is where it's key to understand the first part of the report, talking about how AI is trained. The office acknowledges that AI training often involves using entire copyrighted works. Originally, such wholesale copying weighs against fair use. However, the report notes that copying an entire work might weigh less heavily or be considered reasonable if it's justified by its transformative purpose. The office suggests that certain types of AI training using entire works appear to be necessary, to effectively generalize so these models and AI systems can perform as they're intended. So if there's a legitimate transformative purpose, the extent of copying may be deemed reasonable. A crucial consideration here, though, is the amount of the original work made accessible to the public through the AI's output. If a model developer implements effective guardrails, technical measures to prevent the AI from generating outputs that might reproduce copyrighted content wholesale, then this factor will weigh less heavily against fair use or potentially not at all. The fourth and final factor is the effect of the use upon the potential market or value of the copyrighted work. The office takes a pretty broad view here. It's not just about direct loss of sales if AI generates a copy of a work. They point to market dilution as a serious concern. If AI floods the market with works that are similar in style to what it is trained on, it could devalue the original human-created works. Lost licensing opportunities are a major consideration as well here. If there's a developing market for licensing content for AI training, and a company were to bypass that, claiming fair use, that's going to harm the market. So in summary, with these four factors, it's nuanced. The report concludes that some uses will likely qualify as fair use and some will not. Non-commercial research where AI doesn't produce original elements is more likely to be fair, but commercial AI use that is utilizing substantial copyrighted material to generate competing content may go beyond established fair use boundaries.
Lastly, the report mentions licensing, and I know we've seen a lot of companies engage in licensing, especially after some of the copyright infringement claims have come out. What are the takeaways with respect to licensing that we can get from the report?
So the office does acknowledge that voluntary licensing is happening. So as you mentioned, we're seeing deals being made, both direct licenses with individual right holders and some collective licensing efforts. So the concept isn't impossible. However, the report also highlights significant challenges. The sheer scale and diversity of data that some AI models require can make licensing incredibly complex and potentially very expensive. The report also, in response to this complexity, acknowledges compulsory licenses, where the law would compel rights holders to license their works for certain uses at set terms. But the Copyright Office did not make a recommendation for compulsory licenses at this stage. The report notes very little support from the stakeholders they interacted with for things like compulsory licenses or extended collective licensing terms right now. The main concern with compulsory licenses is their inflexibility, and they set the terms very quickly. And the report is acknowledging, hey, this technology is moving even faster, and we don't want to potentially hinder this industry. So the Copyright Office current recommendation is to allow the licensing market to continue to develop without government intervention. They're essentially saying, hey, let's see how these voluntary markets evolve. If significant market failures become apparent down the line in specific areas, then maybe a more targeted intervention is appropriate.
Thanks, Joe, and thanks for sharing your summary and insights for the report. Any final takeaways for our listeners?
Our listeners are going to be frustrated, but the key takeaway is that nuance is paramount. Everything is currently on a spectrum. So there's no easy yes or no whether AI training is fair use, and it truly depends on those specific facts.
Thanks, Joe, and thanks to our listeners for listening to AI Council Code. We're so glad that you joined us today. Stay tuned for additional podcasts and more insights on AI legal issues from Baker Botts.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.